case briefs, and so much more. LSData's got what you're looking for.
The Supreme Court case of Gagnon v. Scarpelli, decided in 1973, called into question the right of an indigent probationer or parolee to a fair hearing and appointed counsel in the event of parole or probation revocation. It set the tone for conversations around probation and parole rights and obligations in America. The case centered around Gerald Scarpelli, who, having been sentenced to 15 years imprisonment for armed robbery in Wisconsin, had his sentence suspended in lieu of 7 years of probation. However, when Scarpelli violated his probation terms by associating with known criminals and getting involved in a burglary in Illinois, his probation was immediately revoked, his original sentence instigated, without a fair hearing or counsel provided. Several years into his incarceration, Scarpelli argued that the lack of a hearing and counsel during his probation revocation violated his due process right and applied for a writ of habeas corpus. Recognizing the violation of due process, the district court granted Scarpelli the writ of habeas corpus. This decision was upheld by the Court of Appeals, which supported Scarpelli's right to due process and the requirement for a fair hearing before the revocation of his probation. The case was eventually brought before the Supreme Court to clarify the extent to which due process rights extend to indigent probationers or parolees, particularly regarding the state's obligation to provide counsel in all revocation cases. The Supreme Court partially reversed and partially affirmed the decision. While it did uphold the necessity for a writ of habeas corpus and a new hearing consistent with due process standards, it highlighted that introducing counsel into every probation revocation case significantly alters the nature of the proceeding, shifting focus from rehabilitation to criminal trial. In conclusion, while the Supreme Court emphasized nebulousness of such proceedings and the importance of a fair hearing before revocation, it also shrewdly avoided making sweeping judgments about the need for counsel in all revocation cases, thus leaving discretion for state authorities.
Case briefs, and so much more. LSData's got what you're looking for. Visit LSD.law, elevate your mind. Leave the stress of class.